prosecution is afraid of the consequences of medical report. Maybe the prosecution is afraid of the consequences of medical report because they know that they will lose their case if if the intervention of an expert is sought in this case. So just to conceal your defects, you have deliberately not acted upon collecting scientific evidence. What do you have to say about it?
I would like to contend that there were threat calls and also attacks on the investigating officer. So it might not been even possible for him to conduct any medical test because of that threats. He might be under the pressure of the threat calls, which was.
So you mean to say that the police were not able to do their job under threat?
I'm not saying that they were not doing their job according to the provision.
Yeah, see, not collecting scientific evidence is nothing but it's nothing but not conducting the investigation properly. What is the purpose of investigation? The purpose of the investigation is to gather the evidence in order to establish the case against the accused beyond all reasonable doubt, isn't it? If you are really sincere to establish the case against accused, what has stopped you from not resorting to medical examination?
Because there were enough evidence to prosecute the accused. The medical.
What was the enough evidence when it comes to consumption? WhatsApp chats and the self-confession given by the accused to the police officer.
Not only the self-confession.
So you mean to say that Sameer Ahmed need not consume lunch if he simply do chatting that is more than sufficient to fill his stomach?
No, sir. The actions also speaks. So his action at the party, being a host of the party, and also only his close friends were there. So it can be said that he was in the conscious possession of the drugs. So he can be convicted.
That position I am not disputing. I am not disputing the position. The facts are very clear about it. Anyways, anything else? Counsel, anything else?
With your it is my humble contention. I would like to conclude my submission with your permission.
No, you have already what is your submission?
My submission is that the accused can be booked under the possession as he was in conscious possession.
The accused has already been prosecuted for that. They were convicted. We are here only to see the validity of lower court order. So what do you want me to do finally? You have concluded your arguments. What do you want me to do?
We want the accused not to be acquitted.
Okay. So you want us to confirm the order of the lower court?
Yes, sir.
What about enhancement of punishment? Your co-counsel was making such suggestion.
Yes.
What do you have to say about it?
My counsel was right.
Let him do his job.
My counsel was right, as the punishment for the commercial quantity is up to 10 years, and the special court was only convicted him for the 2 years only. So the punishment can be enhanced.
Good. So if according to you, the punishment which was given by the lower court was not sufficient, then what has stopped you from not preferring an appeal? Why didn't you prefer an appeal against the order of the lower court?
Because considering
the punishment is inadequate.
2 years might have been.
Okay, so you are lenient, right? You are lenient. That's the reason you have not preferred an appeal.
Yes, sir.
But you want this court to be harsh. You want to take the liberty of being lenient. You want the executive to be lenient by not preferring an appeal against the insufficient conviction or sentence, but you want this court to be harsh.
We don't want you to be harsh. We just want you to uphold the judgment of the special court.
But you are not on the point of enhancing the punishment, what it has been stated by the first speaker from your side.
It can be enhanced, but considering into account that he was a teenager and 2 years is enough for him to be.
So you are sailing with the other team on the ground of mitigative factors instead of taking the side of your co-counsel.
I am just supporting his arguments that it can be enhanced, but considering into account the society, as he
I
has mentioned
appreciate
that,
your candid submission. I appreciate it. Very good. Anything else, Mr.?
we would like to move on to the prayer of relief, with your permission, sir.
No, I read it. You have told me to affirm the lower court order, keeping the age of the accused in view. Isn't it?
Yes, sir.
Without pressing on the enhancement of sentence. Yes. Thank you. Anything else?
It was pleasure pleading